Good afternoon, all. Thank you for joining us on the sixth session of Environmental Law Lecture Series organized by MLNG Society's Manikchand Pahade Law College, Aurangabad. It's a glad welcome we bring to you, filled with the desires, hopes, and dreams we all share. I request Dr. Aparna Kotapalle, ma'am, lecture series coordinator as well as IQSC coordinator of MP Law College to give the welcome address. Over to you, ma'am.
Thank you, Rajeshri. It gives me immense pleasure to welcome all in the last session of the Environmental Law Lecture Series that is continued to happen during this week. Now we have reached to the fag end of the lecture series, and maybe in the earlier sessions we have talked about theoretical perspectives, concepts as like various kinds of pollution, forest and law, animal related law, biodiversity kind of things. Then the procedural parts like public participation in the environmental impact assessment processes. And after discussing plethora of references and the theoretical perspectives, now we have reached to the practical point of view, wherein now, as we all know, that the matters are being referred to the National Green Tribunal now after 2010. And so as to guide all of us, Advocate Saurabh Kulkarni from Pune, who is practicing advocate at NJT, is amongst us, and we are happy to welcome you, sir.
Thank you.
Thank you, sir. Now, I also welcome our respected principal, sir, vice principal, sir, all the faculty members, student participants, and all the participants, not only from our college, but from other colleges and from from various courts. Those who have joined us on this particular Zoom platform, as well as I welcome all those who are attending this event on our college YouTube channel. So, welcoming you all for the last session. I hope this would be very interactive session. Maybe theoretically we have learned, we might have read about the provisions and the process, but listening it from the person who is actively involved in the actual process of reaching to the justice, it would be more interesting, I suppose. Before stopping from my side, I would just give you two instructions. For the two parties for the participants, there are two instructions. One is I would be sharing the link of feedback in the chat box. I expect you to give your valuable feedback at the end of the lecture, not in between. And secondly, there is a question answer box in which you may place your queries, and I would request Sir Kulkarni sir to deal with those questions after your lecture, sir. So, heartiest welcome to everyone, and thanks to the organizers for giving me this opportunity. Thank you one and all. Over to you, Rajeshri.
Thank you so much, ma'am. Today on the sixth session, we have with us Advocate Saurabh Kulkarni, sir, Advocate Pune. Sir will share his findings on National Green Tribunal practice and procedure. It doesn't matter what's written in your story. So far, it's how you fill up the rest of the pages that counts. So I, Rajasri Saure, LLB third year student of MP Law College, took immense pleasure to introduce our today's resource person to experience the excellence of respected advocate Saurabh Kulkarni. Graduated from University in 2007, respected sir enrolled as advocate on 3rd July 2007 with the Bar Council of Maharashtra and Goa. Thereafter, sir proceeded to UK and completed LLM in International Commercial Law from University of Birmingham and submitted dissertation on takeover regulation, comparison of mandatory bid and equal opportunity codes, and a thesis on takeover laws in UK, USA, Austria, and New Zealand. Respected sir is also a registered trademark attorney and have appeared before various courts and tribunals, from Labour and Industrial Court Pune to the Apex Court of India. The journey isn't stopped here. Sir is having tremendous experience of practice in the areas of arbitration, company law, environment law, litigation, and many more. At present, since 2012, Sir is managing and handling their own firm. We are very fortunate and honored to have such a experienced resource person among with us. Before Advocate Kulkarni sir address us, I am instructed, this program is followed by a question and answer round. Attendees who have any question, any query can post it in the question and answer box. And I further want to remind you that the feedback link is available in the chat box. Please kindly fill up and submit the feedback link after this session. Now, I request Advocate Saurabh Kulkarni sir to enlighten us. Over to you, sir.
Thank you. I thank the Law College for giving me the opportunity. May I request you to please share the presentation, please? May I request you to please share the presentation? Yes. May I request for the next slide? Yes. So when we talk about the NGT or the National Green Tribunal, the first question which comes to our mind is that what is this tribunal about? So this tribunal is about redressing the grievances and dispute pertaining to environment. And then what is environment? The environment which has been defined in the act also says that it is environment consists of water, land, air, and the interrelationship of these three with the human beings. So when there is a destruction of the environment, or where there is a environment which has been hampered with, then where two parties have to go? Then this is the tribunal where the parties have to approach. Now, the Indian Constitution, which is the base of all laws in the country, has given us it has given us a structure wherein the duties and fundamental rights of citizens relating to environment have been enshrined in. Now, in Article 21, which grants us the protection of life and personal liberty, it also assures every Indian citizen of a right to a healthy environment. When I say healthy environment, it includes clean air to breathe, clean water to drink, and also a pollution-free environment to live into. Now, when the drafters of the constitution decided to draft certain provisions relating to environment, article 51A, which was inserted later on, which also says that it is a duty of every citizen to protect and improve the natural environment, which includes forests, lakes, rivers, and wildlife, and to also have a compassion for living creatures. That is why it is very much important for us as citizens, when we travel through the length and the breadth of the country, to protect the environment and to protect the natural resources which the environment has given to us. The Indian conditions are such that we have everything, right from the snow-clad mountains to the deserts to the islands to everything. So it is our duty as a citizen to protect them. Further, Article 48A, which was inserted in the year 1971, which also says that the state shall endeavor to protect and improve the environment and also to safeguard the forest and wildlife of the country. This means that it is also the duty of the state to ensure that its citizens are provided with a clean and better environment to live, and also that the forest and wildlife of the country are protected. May I request for the next slide, please? Now, in the year 1986, in the year 1984, there was a accidental tragedy which took place in our country, which was the Bhopal gas tragedy. On account of that accident, many people lost their lives. So the government of India also decided to enact a special legislation which was known as the Environment Protection Act. The Environment Protection Act was brought into force in the year 1986. Now, the Environment Protection Act basically talks of various rules, and it also gives us the discharges which the every activity has to, the discharge rules for the every activity to follow. Like if we are operating a stone crusher, what are the discharge norms, or what are the norms the stone crusher has to follow, or a company or a hotel or a hospital, etc. Also, the Environment Protection Act has stringent provisions pertaining to punishments. So, if a person who has been found to be polluting the environment, he is liable to face punishment in accordance with the Environment Protection Act, which at present is like fine up to 2 lakh of rupees and imprisonment of up to 5 years or both. Under the Environment Protection Act, the authorities have also been empowered with various powers to issue directions, like it can stop the electricity and water supply of a company if the company is found to be polluted. It also has the power to issue notifications. So under the Environment Protection Act, the Ministry of Environment, Forest and Climate Change has issued the most important document till date in the country, which is the EIA notification of 2006. Under that notification, every activity has been stated which is required to obtain a prior environmental clearance. Now, coming to the Constitution of National Green Tribunal, we need to focus on the background, what led to the formation of the NGT. Now, the Rio Conference of 1992, the United Nations had a conference conducted in Rio de Janeiro in 1992, which was also known as the Earth Summit. Now, India was one of the signatory to that conference. Now, there were certain issues which were relating to the pollution happening in all over the countries, or the carbon footprint which was increasing on the global platform. The countries decided to enter into an agreement to ensure that its residents are protected from the destruction of the environment, and also have been empowered with certain rights in case they are faced with certain pollutant discharges. So the issues which were addressed during that conference, I have just highlighted them in the screen. That was systematic scrutiny of patterns of productions, particularly the production of toxic components such as lead in gasoline, or poisonous waste including radioactive chemicals. Now, every one of us are aware that India is a manufacturing hub, and there are a lot of chemical industries which operate in the country. So with the increase of the manufacturing products, the companies have also to ensure that they follow various legislations and various rules in ensuring that there are no chemical hazardous accidents which take place. Second is alternative sources of energy to replace the use of fossil fuels, which delegates linked to global climate change. Presently, we are now also going ahead with the electronic cars. We are also relying upon the solar energy. We are also using CNG vehicles, which are an alternative fuels for petrol, diesel, and also the LPG. Then there was a new reliance on public transportation systems in order to reduce vehicle emissions, congestion in cities, and the health problems caused by polluted air. In India, we are seeing various cities have opted to introduce the metro rail. There are also discussions to start the hyperloop. So these alternate modes of transport may directly have a tremendous impact on the carbon footprint, which is being discharged by the cars when we are stuck in the traffic jams and etc. The growing usage and limited use supply of water. Now, water is a commodity which is likely to be a scarce commodity in the near future. So it is our duty as a citizen to ensure that we use limited water, and whatever water is being utilized, it has to be recycled. Next slide, please. Now, the National Green Tribunal was a concept which was decided by the government to bring it into action after signing the Rio Conference Accord. India is the third country in the world to have such a tribunal after Australia and New Zealand. In Australia and New Zealand, they do have a tribunal which deals with environmental issues, but it is only acting as an advisory body. But India is the only country in the world having a tribunal which can exclusively deal with only environmental issues. So this decision of the government to introduce a bill to enact the National Green Tribunal was introduced in 2009. After various discussions in the parliament, the National Green Tribunal Act was passed in the year 2010, and the National Green Tribunal came to be established in 2010 at New Delhi. And the object of setting up of this tribunal was for speedy disposal of cases pertaining to environment protection, conservation of forest, and also for parties to seek compensation in case of damages which has been caused to their property or health on account of violation of environmental laws or pollution activities by various projects. May I request for the next slide, please? Now, what was the need for the government to enact the National Green Tribunal Act? There were, as I stated in the earlier discussion, I have stated about the Bhopal gas tragedy. There were various cases like the Vellore Citizens Welfare Forum and the Karnataka Industrial Areas Development case before the Supreme Court, wherein for the first time the concept of sustainable development and polluter space was discussed. Now, what does sustainable development mean? The development which can also sustain at the point where the environment is not destructed at all. So we should also go for development, but that the development should be in such a nature that we do not cause any destruction or harm to the environment. What does the polluter pay principle says? The polluter who causes a tremendous amount of pollution is liable to pay for the pollution which is caused and destructed the environment. Not only that, he has to restore and restitute the environment. The Supreme Court has dealt with these cases and have laid down its law on these two terms. Also, the case of absolute liability was dealt in the Bichri village case. In the Bichri village case, the Supreme Court said that the person who has been engaged in an hazardous activity, and if at all there is an accident caused on account of the said activity, he shall be liable and he shall be held to be absolutely liable to restitute and remediate the environment. In all these matters, the Supreme Court requested the Union of India, the government, to enact a legislation where a tribunal could be set up to decide the environmental disputes, as the Supreme Courts and High Courts were burdened with a lot of environmental issues, but they were not having the appropriate expertise to deal with these cases. And also recently, after the lockdown was relaxed, we have read in the newspapers and also in the on the electronic media, there were a lot of accidental cases of gas leaks and fires which took place in the companies. All these cases were thereafter dealt with by the National Green Tribunal. May I request for the next slide, please? Before the existence of the National Green Tribunal, the government had enacted a legislation which was known as the National Environment Appellate Authority Act 1997. So that act enabled an authority to be constituted which dealt with only appeals and disputes relating to the environmental clearance. So the scope of that authority was very narrow, and only the disputes which pertain to the environmental clearances were dealt by that authority. So which was not serving the purpose as to the assurance which India had given in the Rio conference. So the National Green Tribunal came to be established. The first bench of the National Green Tribunal, which is also known as the principal bench, was set up in the national capital at New Delhi. Subsequently, the regional benches were set up in Pune for the entire western zone of the country, Bhopal for the central zone of the country, Chennai for the southern zone, and Kolkata for the eastern zone. Each bench has been given a specific geographical jurisdiction, and there is also a mechanism to constitute circuit benches. Now, the bench at Pune started in August 2013. The bench at Pune has jurisdiction over the states of Maharashtra, Gujarat, Goa, the Union Territories of Daman and Diu, and Dadra Nagar Haveli. The constitution of the National Green Tribunal consists of the expert members and the judicial members. Now, expert members are the members who have a professional qualification in the field of environment and having at least 15 years of experience in the said field and any other related subject. As I stated that India is only the third country in the world to have a tribunal like this after Australia and New Zealand, and the only country in the world to have a tribunal which consists of an expert member and a judicial member, which helps the bench to adjudicate the issues relating to environment efficaciously and also expeditiously. May I request for the next slide, please? The powers of the NGT have been enshrined in the National Green Tribunal Act. As stated, that the constitution of the NGT consists of a judicial member and an expert member, and it has been headed by a chairperson who is a retired judge of the Supreme Court. Now, the powers, the NGT has been given powers under the various enactments, which I have just shown on the screen. So under Schedule 1 of the NGT Act, the following acts can be, the disputes from the following acts can be tried by the NGT. The acts are like the Water Prevention and Control of Pollution Act 1974, the Water Prevention and Control of Pollution Cess Act 1977, the Forest Conservation Act, the Air Pollution Act, the Environment Protection Act, and the Public Liability Insurance Act, and also the Biological Diversity Act. Now, amongst these 7 enactments, the most important enactment is the Environment Protection Act, because under the Environment Protection Act, which is also further subdivided into various rules, which pertains to the e-waste rules, the plastic waste management rules, the solid waste management rules, the batteries rules, also the plastic waste management rules. So under these rules, the authorities have been empowered to take action as per the rules as prescribed under the Environment Protection Act. May I request for the next slide, please? Now, what is the procedure for filing an appeal or application before the NGT? Under the NGT Act, the 3 most important sections are Section 14, Section 15, and Section 16. Now, Section 14 is the original jurisdiction which the NGT has been empowered with. So any person having a dispute which relates to a substantial question relating to the environment and which has accrued 6 months prior to filing of the case can approach the NGT by filing an original application before the NGT. Now, when he files the application before the NGT under Section 14, he has to state that what is the harm caused to him, and what is the level of pollution which has taken place, and what efforts he has taken to approach the authorities prior to filing of the original application. When he files the original application, he has to give in all the material particulars pertaining to the said incident. The limitation, as I stated in under Section 14, is only 6 months on the date when the cause of action has first arisen. The tribunal also has a power to condone the delay of up to 60 days after filing of the application. So that gives you effectively 8 months period to file a petition under section 14 before the NGT. After section 14, the next most important section is section 15. Section 15 pertains to restitution, remediation, and compensation. Now, when a project or when a project proponent is involved in the destruction of the environment, if the NGT finds him that he is liable to restitute and remediate the environment, the directions are issued to such effect that the authorities have been directed to ensure that the project proponent restitutes and remediates the environment to its original position. And also, the NGT has the power to direct the project proponent to grant compensation to the population which has suffered on account of the setting up of the project. When an application is filed under section 15, it has to be filed along with the form 2, which is given in the NGT Act, and in the form 2 all the material particulars like when the incident took place, what happened exactly, what are the actions which the authorities have taken, whether there was a police complaint filed on behalf of the person who suffered the damage, and what is the cost of damage approximately which he has suffered on account of the said pollution. Along with the filing of the said application, he has to also pay 1% stamp duty. Coming to the next section, section 16, which deals with the appellate jurisdiction of the NGT. Every project receives a permission from the local pollution control board and also receives an environmental clearance from the Environment Impact Assessment Authority. When the company or the project receives an order of closure or receives any order from the authority, which is mentioned in the 7 enactments I just showed in the previous slide, can approach the NGT by filing an appeal. That appeal will have to be filed within a period of 30 days from the date when the order was communicated to him. The NGT has a further power to condone a delay of approximately 60 days. So effectively, you get a period of 90 days to file a case which has to challenge an order issued by any statutory authority as an appeal before the NGT. The procedure which has been enshrined in the NGT Act pertains that the NGT Act has to be, the application has to be filed along with a court fee of rupees 1,000, and no, as I stated, that the limitation has to be strictly followed by the NGT. That is 6 months in the case of section 14 application, 5 years in the case of section 15 application, and 30 days in the case of section 16 appeal. May I request for the next slide, please? Now, what are the procedures and the principles that the NGT has to follow while dealing with the cases it receives under section 14, 15, and 16? It has, the most important part that the NGT has to do is it has not to follow any procedure in any other law. It can devise its own procedure. However, it can take the guided principles as laid down in the Code of Civil Procedure 1908 while adjudicating the disputes. The most important aspect which the NGT has to do is to follow the principles of natural justice. Now, what are the principles of natural justice? That whenever it receives a petition, it has to issue a notice to all the parties. It has to take on record the submissions, the documents, and the replies submitted by those parties. It has to give a patient hearing to all the parties and give a speaking order. So, as we say that justice is not only has to be done, but it should be seen that it has been done. So the principles of natural justice are the utmost important principle that the NGT has to follow. However, the technical procedures which have been enshrined in the Code of Civil Procedure and the Indian Evidence Act are not required to be followed by the NGT. It can devise its own procedure. However, while passing of the orders and decisions and awards, the most important principles that the NGT has to follow as per section 20 are sustainable development. As I stated, that development which can sustain the development as well as the environment. Then secondly, the precautionary principle. The precautionary principle is like when a project which is likely to come up and the NGT, if it feels that on account of the setting up of this project, the environment is likely to be harmed, then by applying the precautionary principle, the NGT can pass an order directing stoppage of work of that project. And as I stated earlier, polluter pays. So the NGT has to follow these principles in totality, and while laying down its law and when passing the judgments, we should see the import of these principles in the said orders. However, NGT also has power to deal with false claims and including imposing of costs and also ensuring that such litigants are not entertained by it in future. May I request for the next slide, please? There is also a procedure for review mentioned in the NGT Act. Under Rule 22 of the NGT rules, there is a provision of seeking a review of the decision or order of the NGT by filing the review application within a period of 30 days. However, when a decision of the NGT is required to be challenged, it can be challenged only before the Supreme Court within a period of 90 days. However, the Supreme Court also has a power to condone a delay by showing sufficient cause after a period of 90 days. May I request for the next slide, please? Now, there are certain frequently asked questions in respect of NGT. Now, what is a difference between the court and a tribunal? The Supreme Court had the occasion to answer this question. It has stated that every court may be a tribunal, but every tribunal necessarily may not be a court. So as I stated earlier, the National Green Tribunal is a creature of a statute. It has to only follow what the National Green Tribunal Act says. It cannot go beyond the statute known as the National Green Tribunal Act. Going beyond that can be the order which has been passed without jurisdiction and can be immediately caused by the higher court, that is the Supreme Court. However, the Supreme Court and the High Court are constitutional courts and they have wide-ranging powers, including enactment of all laws. So, for an example, if NGT cannot go beyond a dispute which has taken place for more than 5 years in case of a Section 15 application, or it cannot condone a delay of more than 60 days. However, if a sufficient cause is shown before these courts, the courts can very well entertain such cases. May I request for the next slide? Whether protection of a national park or a sanctuary from various pressures or including a dam proposal, should NGT be approached? As stated, the NGT has to follow only the disputes which are mentioned in Schedule 1, that is only the disputes arising from the 7 enactments of the section of the Schedule 1. So any dispute arising out of these 7 disputes cannot 7 enactments cannot be entertained by the NGT. Next. Whether you can appear in person before the NGT, yes, a person need not approach a lawyer all the time for filing a case before the NGT. He can do it on its own. But however, it is always advised and suggested that if a lawyer is hired by you, it will be better equipped. He will be better equipped to argue and handle all procedural aspects. Recently, the NGT, on account of the present pandemic, has also started the provision of filing the petitions online. So the question of locus is not important before the NGT. For example, a person residing in Kanyakumari can also file a case before the NGT relating to an environmental destruction held in Kashmir. So the NGT is quite open in respect of the locus and a person approaching before it. Next. What is the penalty for non-compliance of an NGT order? So if the judgment or an order passed by the NGT is not followed in totality by the project proponent or by the authority, the penalty can be imprisonment of 3 years or a fine which may extend to up to 10 crores or both, and continued failure will attract a fine of 25,000 rupees per day. We have seen in various cases before the NGT that the senior most officers of the authorities have been summoned. In the case of the Pollution Control Board, the chairperson or the member secretary have been summoned by the NGT, and they were required to apologize before the NGT for passing orders which are not in conformity with the legal provisions. Next, whether civil courts can take up any issues pertaining to the 7 enactments as mentioned in the Schedule 1 of the NGT Act. The civil court will thus have a bar now with the enactment of the NGT Act in the 2010. So a person cannot file any dispute which arises out of the 7 enactments before the civil court relating to the substantial question of environment. Hence, there is a bar to approach the civil court. May I request for the next slide, please? Now, there are certain important cases which I would like to discuss. The Pune bench of the NGT had an issue to deal with in the case of Ms. Betty Alvarez versus the state of Goa. Here, the applicant, that is Ms. Betty Alvarez, she was a foreign national belonging to the Portuguese descendancy, and she had filed a case before the NGT pertaining to certain polluting activities in the state of Goa. The project proponents who appeared before the NGT had raised a preliminary objection that the applicant, not being a local resident or a citizen of this country, cannot file a case before the Honorable Tribunal. The National Green Tribunal then replied and passed its judgment and stated that it relates to a substantial question of environment and the case cannot be dismissed only on this preliminary objection. And it held that even a foreign national who has been residing in this country and is a witness to an environmental destruction can very well approach this tribunal and file a case relating to this. The next case, which is about Almitra H. Patel versus Union of India. There, under this case, there was a complete prohibition on open burning of waste on lands. Now, we see that whenever we go for morning walks or wherever we go in the parks, we see that the municipal workers have a job to do of sweeping the streets. We see that they pile up the waste in one corner and they just burn that waste. As per the decision as per the decision of the Honorable Tribunal passed in this case, there is a fine of rupees 5,000 to be imposed upon that person who burns waste on the open lands. Saloni Singh versus Union of India. As I stated in the earlier part, the Environment Impact Notification 2006 has stated various activities which are required to obtain a prior environmental clearance before starting with the activity. So the railway activities, that is the railway stations, have been omitted from the notification. The NGT had to deal with this issue, and then it had said that the major railway stations which having the potential of causing pollution cannot be omitted from the environmental impact assessment, and they directed the railway authorities to conduct the impact assessment of such railway stations and file a report before it. Shailendra Singh versus Union of India. In rural parts of the country, we see that we still the residents do not have the potable water for drinking. Hence, they have to rely upon the groundwater. Even in the industrial areas, we see a lot of industries extracting groundwater for its own usage or for manufacturing activities. Now, because of this, there is a depletion of groundwater, and the residents have left with no option but to go and buy water from outside sources. So the NGT was dealt with an issue pertaining to certain industries in Haridwar. It mandated that the Central Groundwater Authority should issue a notification, and it mandated that all such activities requiring groundwater for commercial purposes have to obtain the no objection certificate of this authority prior to extracting groundwater. And on account of this, the illegal extraction of groundwater came to a halt on account of the action taken by the pollution control boards. Aditya Puri versus Union of India is one such case which the NGT has dealt with recently. In this case, a minor through his guardian had filed case against Amazon, Flipkart, who used tremendous plastics for packaging. So the NGT directed the companies and the pollution control boards to ensure that the plastic used in the packaging is not under 50 microns, which is the requirement of the Plastic Waste Management Rules 2016. So the project proponents were directed to ensure that low quality plastic is not used during the packaging. May I request for the next slide? Now, these are certain cases dealt by the principal bench and also the regional benches at the of the NGT. Now, capital ban on old vehicles. This is a case where there was tremendous pollution in the capital city. So the NGT passed a judgment stating that vehicles which are 15 years older should not be seen on the road. And on account of this, now the government of India is coming up with a vehicle scrapping policy. Ganga rejuvenation. Now, Ganga rejuvenation is a case where the river Ganga, which is considered to be a holy river in the Hindu culture, was found to be polluted in lots of places in the states of Uttar Pradesh and Uttarakhand. So the NGT took it upon itself and passed a judgment running into almost 550 pages, where it has passed a slew of directions to the authorities to ensure that industries do not discharge the waste directly into the river. This exercise has taking place since 2016, and the authorities have somewhat been successful in controlling the pollution in the river Ganga. Now, Meli se Nirmal Yamuna revitalization project. This is also on the similar ground of the river Ganga case, where there was tremendous pollution from the states of Haryana and Delhi in the river Yamuna, which led to a lot of activities being banned, which were in the states of Haryana and Delhi. Now, as I stated in the earlier slide, the case of Aditya Puri, where the plastic items which were below 50 microns and which are prohibited under the Plastic Waste Management Rules 2016 have been banned by the NGT, restricted traffic to Rohtang. We all are aware that Rohtang Pass is a very scenic place in the state of Himachal Pradesh near Manali. So there was a lot of traffic which was causing tremendous pollution in the said area. The NGT found that because of this, the environment was getting destructed and the snow layers were depleting. So only 800 vehicles were permitted for a day at Rohtang Pass on account of the judgment of the NGT. The NGT further directed the Himachal Pollution Control Board to ensure that only CNG or preferably a vehicle which is of the alternate source of energy can be permitted in future. The Himachal Pradesh Pollution Control Board is working on the policy, and maybe that policy will be out in a year or so. Now, the case of stubble burning. Every year in the months of October and November, Delhi is choked because of the stubble burning caused by the farmers in Punjab, Haryana, and Uttar Pradesh. The NGT had taken suo motu cognizance of these incidents and passed directions, and directions were like imposing fine upon the persons who were causing a lot of stubble burning, on account of which the air quality of Delhi, which is the national capital, was deteriorating. The NGT also passed directions of imposing fines upon the farmers to ensure that stubble burning does not take place. They also directed the pollution control boards to educate the farmers to ensure that they go for alternative methods and not engage into stubble burnings. The next case is a cap on number of Vaishno Devi pilgrims. The Vaishno Devi, which is located on a higher altitude in the state of Jammu and Kashmir, the on account of lots of pilgrims visiting the said area, there was a lot of pollution which was taking place, such as the plastic pollution or the pollution of throwing of the solid waste. So the NGT restricted that per day only 1,500 pilgrims were permitted to Vaishno Devi. Now, silence at Amarnath, even at Amarnath, the snow-clad cave, which the yatra takes place in the months of June and July, because of tremendous load upon the tourism sector on account of visit there, the NGT passed directions to ensure that the Amarnath remains a silent zone and that the pilgrims ensure complete peace while on the pilgrim. The Art of Living case. The Art of Living had organized a concert in Delhi on the Yamuna floodplains. Now, because of the floodplains, when the structures were erected on the floodplains, it caused tremendous destruction of the environment to the floodplains. The NGT directed the Delhi Pollution Committee to ensure that the environment is restituted and remediated by the Art of Living Foundation, and they imposed a cost of rupees 5 crores on the said foundation. The case is unfortunately still pending before the Supreme Court, and we are expecting a verdict upon it. As relating to the case at Aurangabad, in Aurangabad also, we all are aware that the areas of Waluj and Ranjangaon, Shepunji is an industrial belt. In 2013, the NGT at Pune had dealt with a case relating to the water pollution caused because of the discharge from the industries in the Aurangabad the zone in the rivers. And that is why some farmers had approached the NGT, and NGT had ensured that MPCB, that is the Maharashtra Pollution Control Board, identifies the polluting industries. And not only that, the polluting industries should be identified and they should be imposed with severe damages on account of the pollution caused by them. Next slide, please. Yes, thank you. If there are any questions, you may please go ahead.
Thank you so much, sir, for such an informative session. As such, you have covered all the aspects, so no question has been asked yet.
Okay.
Thank you so much, sir.
Okay, thank you.
Our most valued invited resource person and all attendees, I am very humbled and honored to be the one making the closing remarks and giving the vote of thanks on behalf of our institution. In such a distinguished and intellectually stimulating gathering, we want to express our sincere thanks to Advocate Saurabh Kulkarni, sir, for such an informative session. Thank you so much, sir.
Thank you.
Thanks goes to Dr. Aparna Kotapalle, ma'am, lecture series and IQSC coordinator of for welcome address. I extend our sincere thanks to our principal, Dr. C.M. Rao, sir, and vice principal for Professor S.N. More, sir, for constantly motivating us. And I also like to thank Madhuri Parekh, ma'am, for being with us for today's session. Behind every successful program lies the manifold attempts of our committed faculty. I would like to take a moment to acknowledge the immense contribution of teaching and non-teaching staff of our college. And finally, at the end, I extend my wholehearted gratitude to all our attendees for constantly being with us amongst all the sessions. Thank you so much, one and all. With the permission of dignitaries, I declare this session is end. Thank you so much, one and all.
Thank you.